Hi, this is Lloyd Ehlers, and we are working on Chapter 4 in your Introduction to Paralegal course. Today's chapter is entitled Ethics and Professional Responsibility. Chapter 4 provides a broad overview of legal ethics, beginning with the regulation of attorneys and a discussion of the ABA model code and model rules. Of course, here in North Carolina, we use the North Carolina Rules of Professional Conduct, which are based on the ABA model rules. So let's talk about just an overview of ethics in the paralegal. Regardless of which career path you choose to follow, you should have a good grasp of your state's ethical rules governing the legal profession. When you work with an attorney as team members, you'll share the ethical and legal responsibilities arising from the attorney-client relationship. In preparing for a paralegal career, you must know what these responsibilities are. It's your responsibility to know what your responsibilities are, why these responsibilities exist, and how they affect you in your everyday practice. If a paralegal violates a rule governing attorneys, it may result in serious consequences for the client, for the attorney, and of course, thereby for the paralegal themselves. Paralegals are regulated indirectly by both attorney ethical codes and state laws that prohibit non-lawyers, paralegals in this case, from practicing law. As the paralegal profession develops, organizations continue to issue guidelines that serve to indirectly regulate paralegals. Some of those are the professional paralegal organizations we'll talk about later on, the American Bar Association and state bar associations. Let's look at the regulation of attorneys, because that's where the regulation of paralegals comes from indirectly, because they establish the majority of the rules governing the profession, which are subsequently enforced by state regulatory authorities. The regulation of attorneys by state projects the public interest in two ways. First, by establishing educational and licensing requirements to ensure competence in the profession. That would, of course, be having to graduate from law school, taking the bar exam, being admitted to a bar. By defining ethical rules for attorneys to protect the public against unethical attorney behavior is the second way. Because the rules limiting who can practice law, thus the unauthorized practice of law statutes, are largely written and enforced by lawyers, they also serve to assist lawyers. Unauthorized practice of law, otherwise known as UPL regulations, are covered by the following attorneys' ethics rules. First of all, there's some basic requirements. The bar associations are professional groups of lawyers. Membership in local and national bars is voluntary, while memberships in state bars is mandatory in over 2/3 of the states, including North Carolina. In these states, before an attorney can practice law, he or she must be admitted to the state's bar association. Second is state supreme courts. That's the second regulator. Each state's highest court, often called the state supreme court, is normally the ultimate regulatory authority of attorneys. And that's true here in North Carolina. The judges decide on the licensing requirements for attorneys and the conditions under which the privilege to practice law can be suspended or revoked. The state Supreme Court works closely with the State Bar Association, and the State Bar Association often handles regulatory functions under the authority of the court. That's true in North Carolina. The State Bar Association handles the administrative functions, even though the State Supreme Court remains the ultimate authority. The third regulator is our state legislature. State legislatures regulate the legal profession by passing laws affecting attorneys, such as statutes prohibiting the unauthorized practice of law. In some states, the state Supreme Court delegates significant regulatory responsibility to state legislatures. Final regulatory authority is the United States Supreme Court. Occasionally, the Supreme Court decides issues relating to attorney conduct. For example, the Supreme Court removed the ban on attorney advertising, citing attorneys' right to free speech. Let's talk about some licensing requirements. Licensing gives attorneys the right to practice law and is accomplished at the state level. Each state has different requirements that individuals must meet. The basic licensing requirements, which is true here in the state of North Carolina, are the following. You must have a 4-year bachelor's degree. In addition, you must study for 3 years and of course, graduate from a law school. In all states, this is all states across the country, prospective attorneys must pass a state bar examination. State bar examinations differ from state to state based on that state's laws. Most states also require a multi-state professional responsibility exam on ethics rules. and again, you will take a professional ethics course here during your time at Coastal Carolina. After the other basic requirements, getting a 4-year degree, passing law school, passing the bar exam, you still must be admitted to the state bar. Candidates must pass an extensive personal background investigation to verify their responsibility and qualification to engage in ethical professionalism. An illegal act committed by a candidate for admission in the past might disqualify a person from being admitted to practice law. Let's talk about licensing and UPL, or the unauthorized practice of law. The unauthorized practice of law based restrictions on who or who could not practice law. This is put into place by state statutes beginning around the 1850s. By the 1930s, almost all states had enacted legislation prohibiting anyone but licensed attorneys from practicing law. And that includes paralegals. Most regulatory issues facing the legal profession are directly related to these UPL statutes. The legal profession is also regulated through a series of ethical codes and rules adopted by each state. In most states, the Supreme Court issues an order adopting these rules. A major step towards ethical regulation was taken by the American Bar Association in 1908 when it approved the Canons of Ethics, which considered 32 ethical principles. Most current ethical codes are based, for the most part, on 2 subsequent revisions of those ABA canons. The Model Code of Professional Responsibility was published in 1969 and is known as the Model Code. And the Model Rules of Professional Conduct was first published in 1983 and is known as the Model Rules. Most states, including North Carolina, have adopted some version of the Model Rules, and that's what our North Carolina Rules of Professional Conduct are based on. This 1983 revision, called the Model Rules, is what we're going to base our discussion on in this text, and further updates by the ABA are going to be based on this ABA. So it's really the gold standard in what I think all states are using at this point, certainly North Carolina. Let's talk a little bit about how the Model Rules sanction attorneys. Attorneys violating the rules of professional conduct are subject to disciplinary proceedings brought by the State Bar Association, State Supreme Court, or State Legislature. In North Carolina, the sanctions are brought to the State Bar Association. And again, as I said, the State Supreme Court is the ultimate authority in deciding what's going to happen in regards to violations. Unethical attorney actions are reported by clients, legal professionals, or others to the Ethics Committee of the North Carolina State Bar Association, which is obligated to investigate each complaint. For serious violations, the regulator initiates disciplinary proceedings against the attorney. Let's look at some of the types of sanctions available. There are formal sanctions, which include reprimand, which is a formal scolding of the attorney. This is the mildest form of sanction. Next would be suspension, a serious sanction by which the attorney is prohibited from practicing law for a set period of time, such as 1 month or 1 year, or for an indefinite period of time. And the highest form is disbarment. This is, of course, a revocation of the attorney's license to practice law in the state, and it's for the most serious sanctions. In addition to these sanctions, attorneys can also be subject to civil liability. This is usually in the area of negligence, which is called malpractice in the legal field. Malpractice is a tort law. Torts are wrongful acts committed when an individual fails to perform a legally recognized duty. In this case, the duties that go along with the lawyer-client relationship. Tort law allows one who is injured by another's wrongful or careless act to bring a civil lawsuit against the wrongdoer for damages. And this compensation usually comes in the form of money, of course. A client may bring a lawsuit against an attorney only if the client has suffered harm because of the attorney's failure to perform a legal duty. If the paralegal's breach of a professional duty causes a client to suffer substantial harm, the client may also sue the paralegal. Law firms' liability insurance policy cover paralegals and attorneys, but do not cover paralegals working on a contract or freelance basis. Attorneys and paralegals are also subject to potential criminal liability under criminal statutes prohibiting fraud, theft, and other crimes. I'm going to talk to you about attorney ethics and paralegal practice. Paralegals, in addition to attorneys, must meticulously follow the rules set forth in the North Carolina Rules of Professional Conduct, or whatever state you happen to be practicing in. The rules relating to competence, confidentiality, and conflict of interest deserve special attention. And indeed, both in this course and in our ethics course, we're going to spend a lot of time on those. Those are particularly difficult ethical problems, or they pose particularly difficult ethical problems for both attorneys and paralegals. Let's talk first about the duty of competence. Rule 1.1 in both the model rules and the North Carolina rules talk about the duty of competence, which is placed on attorneys. Competent legal representation is a basic requirement for the legal profession. Breaching or failing to perform this duty may subject attorneys to one or more of the sanctions discussed earlier. So how do you breach the duty of competence? First, inadequate research if you haven't done your homework, missing deadlines, errors in documents, anything along those lines. In order for an attorney to be competent, you have to stay abreast of the law, you have to do your homework, and you have to do the right things for your client. Sort of the rest of the laws that follow. Rule 5.3 is an important one with regards to the attorney and paralegal relationship. Rule 5.3 of the model rules defines responsibilities of attorneys to non-lawyer assistants. That would be paralegals, legal secretaries, anybody that's working in the office that's not a paralegal, that's under their direct supervision. Inadequate supervision is one of the biggest problems we see out there. A paralegal should ensure that the attorney adequately supervises his or her work. No matter how proficient the paralegal becomes, it's still the responsibility of both the paralegal and the attorney to make sure that that attorney is the one that's reviewing all work before it goes out. If you believe your attorney is not adequately supervising your work, here are some things you can do. First of all, try to improve and increase the communication between you and the attorney. Ask the attorney for feedback on your work. Attach a note to a document that you have prepared for the attorney, requesting him or her to review the document carefully before signing it. At some point during your reading, I'd like you to take a look at ethical question number 1, which deals with this adequate supervision issue. Let's move on to confidentiality of information. Rule 1.6 of the model rules, and again the North Carolina Rules of Professional Conduct, concerns attorney-client confidentiality. This is one of the oldest and most important rules in the legal profession. The general rule of confidentiality, as stated in the first paragraph of Rule 1.6, is that all information relating to the representation of a client must be kept confidential, period. There are some exceptions, though, that apply. For instance, if the client gives informed consent to the disclosure of that information, if there's some implied authorization of disclosure, for instance, the information you need to release in order to process a court claim, if a client used an attorney to help commit a crime or a fraud, and the crime or fraud will likely cause injury to the financial interests or property of another person, the attorney has the option to disclose confidential information, but only to the extent necessary to prevent or reduce that injury. And finally, to establish a defense to a criminal charge and a controversy between the attorney and the client. A couple other quick exceptions I'd like to mention. One is disclosure of confidential information is authorized to ensure compliance with the Model Rules of Professional Conduct or the North Carolina Rules of Professional Conduct, to defend against a client's legal action against the attorney, and to comply with a court order or other law that requires such a disclosure. Let's talk briefly about violations of the confidentiality rule. As a paralegal, you can decide never to discuss anything concerning your work, or you can limit your discussion to issues and comments that will not reveal the identity of clients. Conversations overheard by others present some important issues. It's important to avoid the possibility of unwittingly revealing confidential information to third parties. Never discuss confidential information when you're in common areas. If you've ever been around someone who's a loud talker on the cell phone, you know exactly what I'm talking about. If you're out to lunch with a colleague, discussing a client's case has to be done very carefully. Keep in mind that electronic communications and confidentiality are a burgeoning area of the law. Be careful of cell phone use, sending faxes, emails, and things like that. There are some other ways that are important to discuss about violating the confidentiality law. For instance, leaving files or documents on your desk, exposed or visible computer screens, and conversations with third parties. These all go along with your duty to be competent in protecting confidentiality. Next, let's look at confidentiality and the attorney-client privilege. Some confidential information relating to a client's representation is subject to the attorney-client privilege, meaning that it may not be revealed even in court unless the client consents to the disclosure. So what kind of information is privileged? First of all, work product. Usually information concerning an attorney's legal strategy for conducting a case is classified as work product and may be subject to the attorney-client privilege. When does the attorney-client privilege arise? It arises when a client communicates with an attorney regarding a legal matter. It's very broad. This is true even if the lawyer decides not to represent the client, and even if the client has not paid a retainer to the attorney. So this is one of those rules that attaches even though there's no ongoing attorney-client relationship. The duration of the privilege. It comes into existence, first of all, at the moment the client communicates with the attorney concerning a legal matter. Again, even if the attorney decides not to take the case. The client is the holder of this privilege, and only the client can waive it. That means that unless waived by the client, this privilege lasts indefinitely. Next, let's talk about conflict of interest. A conflict of interest arises when representing one client injures the interest of another client. It's covered by rules 1.7 through 1.11. First one I'll talk about is simultaneous representation. If an attorney reasonably believes that representing two parties in a legal proceeding will not adversely affect either party's interest, the attorney is permitted to do so, but only if both parties give informed consent. Normally, attorneys are going to avoid this kind of situation. Let's look at some examples. Divorce proceedings that begin amicably but end up in heated disputes over property division. You can see the problems that might arise there. A family attorney asked to handle a family matter, and the family members eventually disagree on what the outcome should be. I want to talk to you about former clients. Let's look at conflict of interest when it applies to former clients. This stems from Model Rule and North Carolina Rule 1.9 regarding lawyers formally representing clients. The reason for this rule is to prevent an attorney from subsequently using information against a client that they've previously represented. People change jobs. We have different clients come in all the time. And there are some things that new employers or attorneys that have moved from one place to another, paralegals that have moved from one place to another, can do to avoid this problem, including erecting ethical walls around new employees so that they don't run into that conflict of interest. Most law offices have procedures for this in place so that when it happens they can handle it quickly. There are some other conflict of interest situations which your firms will have rules on, for instance, accepting gifts from clients. But the biggest way that firms will avoid problems with conflict of interest is by running conflict checks on cases up front. Each attorney and each paralegal will be subject to conflict checks each time they take on a new client so that they can make sure that they are avoiding these conflict of interest problems. So, moving on to the regulation of paralegals. Interesting to note that paralegals are not members of state bars, and therefore they are not directly regulated by the North Carolina or the Model Rules of Professional Conduct. They are regulated indirectly. So let's talk about that a little bit. Paralegals are regulated indirectly by the ethical codes governing attorneys. Paralegal conduct is also regulated by the standards and guidelines created by paralegal and professional groups. The ABA and various states have created guidelines for the utilization of paralegal services, but keep in mind that the attorney who you work for or with is going to be responsible and is going to be the one that is sanctioned by the State Bar Association because they're the ones that are directly regulated by the State Bar rules. So continuing on with the indirect regulation of paralegals, you know, I've always said, show me a successful law firm or corporate law office, and I'll show you an office with some great paralegals in it. And the scope of what paralegals are required to do these days is just expanding almost exponentially. It may be confusing with some of the other things you're learning these days when we talk about the unauthorized practice of law, because most of the things you're going to be doing as a paralegal seem like they're the practice of law. The important thing to understand is that paralegals can perform almost any task, almost any legal task that a lawyer can, but the work must be supervised by an attorney, and it can't constitute the unauthorized practice of law, which is the unsupervised practice of law by a paralegal. Look to the ABA guidelines and some of the other things out there for more help on this. About half of the states have statutes and a formal definition of the unauthorized practice of law. As I mentioned earlier, North Carolina is one of those. Enforcement of UPL statutes varies widely. In North Carolina, again, as I told you earlier, it can be a criminal violation. So you should know and understand the UPL statutes depending on where you decide to practice ultimately. There are some things which we need to talk about that you have to stay away from. For instance, the prohibition against fee splitting. Under Rule 5.4, attorneys are not permitted to split fees with non-lawyers, and that would include you. Here's one we talk a lot about in all of our classes, and that's the need for caution when giving legal advice. Now, if you've ever had one of my classes, you're going to hear me give my standard, I am not your attorney, we're not establishing an attorney-client relationship, I'm not a North Carolina attorney. I go on to make sure that you understand when you ask me sort of a personal legal question that I am not giving you legal advice. You need to have the same kind of stock answer ready. I am sure now that you're involved in this program that you've heard conversations open up like this. Hey, you're going to school to be a paralegal, right? Or you're studying law, right? And inevitably what comes after that is some request for personal legal advice. And this is a sticky wicket. You also need to have sort of a stock answer that doesn't alienate people but lets them know that you can't practice law. Be careful. Don't give even simple common sense advice if the person you're talking to doesn't understand that you're not an attorney. You can't practice law. Don't advise someone of their legal options. Be on the safe side. Never advise anyone regarding any matter if the advice may alter the person's legal position or their rights. It's a great idea to have them find an attorney who can help them. The general rule is that only attorneys can represent others in legal matters, especially in front of a court. There are two limited exceptions, which we'll talk briefly about. Number one, people can represent themselves. That's when they refuse the help of an attorney. And also, paralegals can represent clients in some federal and state agencies. These are sort of quasi-judicial procedures. An important note regarding disclosing your status as a paralegal when dealing with folks. This should always be done on your business cards, your firm letterhead, in all correspondence. You must somewhere make it clear that you are a paralegal or a legal assistant and not an attorney. So the person reading that doesn't get the idea that they're getting an attorney's advice there. When you're having conversations, make sure that they understand that you are a paraprofessional paralegal and not an attorney. That should help you stay out of some trouble in this area. Just to sort of wrap up today, there's a few sections I didn't touch on a whole lot. Those are freelance paralegals and the discussion as to whether or not paralegals should be licensed. Freelance paralegal is one option for you. However, you really have to be careful to avoid those UPL statutes. So I don't want to spend a lot of time on it. If it's something you decide to get into, I strongly advise you to thoroughly research and make sure that you're avoiding the UPL statutes. One final note, it's important to always think and act in a professionally responsible manner. Keep in mind that you're the ones with the legal training. You're the ones that understand the legal language. And the law recognizes that you should sort of be the senior person in the relationship with clients and non-clients. It's your job to make sure that people you're talking to understand that you can't give legal advice, understand that you're a paralegal, and you sort of have to be the grown-up in the relationship, for lack of a better way to say it. There is very little room in ethics for trial and error. Okay, if you cross an ethical line, you're going to end up in some hot water. Anticipate and guard against violations by understanding the ethical responsibilities of paralegals. Use some preventative tactics. Ask questions when you're in doubt. One of the things I always suggest is use the State Bar Association's hotline. They have an ethical hotline that'll help you get through some sticky situations or stay out of sticky situations. Important to understand that paralegals are regulated indirectly by the attorney's ethical rules. Here in North Carolina, that's true. State laws, North Carolina and other places, prohibit non-lawyers from engaging in the unauthorized practice of law, and that includes you, even though you've had legal training. I hope you found this presentation helpful. As always, contact me with any further questions, and your assignment should be posted on Blackboard for Chapter 4.